Ready? Start. Following the directions given in the writ petition, the second respondent issued notice to the petitioners and they appeared before him on 4 2016. However, they failed to produce the original records before him relating to the induction of 1,450 members in the general body. By the impugned communication dated 18 to 2016, the second respondent has informed the petitioners that in view of failure on part of the petitioners in producing the original records, despite several notices, he is unable to comply with the orders of this court. It has further been observed that in the absence of the original record being produced before him, the induction of new members appears to be doubtful. It has further been noted that in such circumstances, in case compliance of the order of this court is not made, the petitioners will be responsible for the same. The petitioners have approached this court challenging the aforesaid communication dated 18 to 2016 on the ground that power under Section 4B, which has been invoked by the second respondent in issuing the impugned notice, was not available to him as it could only be exercised at the time of registration or renewal of the society. It is urged that in the instant case, no such occasion has arisen as the renewal was granted on 30/11/2011 and is valid for 5 years from 26/9/2011. It is further submitted that the observation in the impugned order that induction of the new members appears to be doubtful will cause serious prejudice to the petitioners as adverse inference is likely to be drawn against them at the time they apply for registration of list of new office bearers under Section 4 of the Act. On the other hand, Sri Nipun Singh, learned counsel, appearing on behalf of the respondents 3 and 4, submitted that since the membership dispute has been raised before the second respondent, any adjudication made by the deputy registrar in that regard is referable to Section 4B of the Act. It is further submitted that in the impugned communication, the second respondent has not declared the induction of new members to be invalid, but only observed that non-production of the original record is creating suspicion on the validity of their induction. The tribunal in its order has observed that by the earlier order of the tribunal as upheld by the High Court, the disciplinary authority has been mandated to reconsider the quantum of penalty as it cannot impose the penalty of removal from service under the facts and circumstances of the case. The tribunal observed that while admitting the fact that in a number of cases minor penalty was imposed, in some cases censure was imposed, and in certain other exoneration was imposed. The order dated 26 April 2002 has attained finality when the writ petition against the same was dismissed in 2002 and the disciplinary authority has chosen not to move the matter before the apex court. In that event, whatever may be the cause or justification, there is no question of same order of removal from service being passed. The authorities have exceeded the jurisdiction. The impugned order of penalty as well as that of appellate order are therefore liable to be set aside. Learned counsel for the petitioners submitted that the tribunal in its order dated 26 April 2002 has affirmed the inquiry report as well as the order of the disciplinary authority to the extent that the charges leveled against the respondent stood proved. Therefore, the order of the tribunal to this extent has not been set aside or modified by the writ court. Thus, the order of the tribunal to the extent that the charges stood proved attained finality. The only question remained for and should not have been awarded or some other penalty would have been awarded. The tribunal has remanded back the case to the disciplinary authority for consideration of the quantum of punishment afresh. It does not mean that the disciplinary authority was prohibited or restrained from levying the penalty of removal of respondent from service. The disciplinary authority on the facts and circumstances and the charges levelled against the respondent having been found proved rightly was of the view that it is a case of embezzlement of public fund and of a misconduct for which appropriate penalty would be the major penalty, that is, removal of respondent from service. Therefore, the view of the tribunal that the major penalty of removal from service cannot be passed by the disciplinary authority is not justified. Source 3P Legal RC exercise number 25. Words are 789 and speed is 102.